I'm going to call the Committee on Judiciary to order. Madam Clerk, will you please call the roll?
Chair Leitner.
Here.
Representatives BeGole.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Yeah. Here.
Hope. Here. Breen. Scott. Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. BeGole moves to adopt the minutes from the June 25th meeting. Hearing no objection, the minutes are adopted. We'll do Rep. DeBoyer moves to excuse absent members. Hearing no objection, members are excused. All right. First order of business. We are going to have Rep. Neyer come up here to the table in regards to his bill, House Bill 4582, in regards to some changes to what used to be open and obvious. We'll see what it's going to be this time. You have the floor.
Thank you, Chair Leitner and members of the committee. Yes, we are talking about open and obvious. What we hope to do with 4582 is to reestablish it. This legislation is designed to restore the clarity and balance that Michigan premise liability laws in light of the change of recent Supreme Court rulings. One such example is Prinsky versus Kroger. For decades, long-standing open and obvious doctrine has provided property owners that had no duty or protection to invitees for hazards that were blatantly apparent. Examples could be such as a hole in the parking lot or a snow-covered sidewalk during a blizzard. These legal standards help maintain a predictability in liability cases. However, the court's recent rulings has shifted this doctrine. Previous legal exemptions to just a factor in the decisions of determining fault. These changes have had costly consequences. Liability and premiums for small business have, in some cases, have tripled and driven up in many and by these increases in litigations and large settlements have taken hold in our small business community. These changes in late 2023 have placed significant strains on local entrepreneurs, small business owners, and commercial property holders. In Michigan, small businesses make up over 90% of all businesses in the state. They account for 48% of the workforce, and small business owners deserve a fair and predictable legal framework to allow their brick and mortar storefronts to exist. I ask for support of these bills. I'll be glad to take any questions, and I have several people, including folks from NFIB, that are willing to testify and give some more background to the need for this bill to be passed.
Thank you, Representative. I'm going to go ahead and invite Amanda Fisher from NFIB, Jacob Manning from the Small Business Association, and Randy Gross from the Michigan Chamber up to join you at the desk here. They all submitted cards and wish to speak, so we'll have those three speak right now in support of the bills. So, Amanda Fisher, you have the floor.
Thank you, Madam Chair and members of the committee. I think this is the first time I've testified here. So my name is Amanda Fisher. I'm the Michigan State Director for the National Federation of Independent Business. NFIB represents small and independent businesses in all 50 state capitals and Washington, D.C. And we've been doing so for over 80 years. So on behalf of our 11,500 members in Michigan, I'm here to support House Bill 4582, which is a step forward toward regaining a fair and reasonable standard in regard to premises liability. So in 2023, as Representative Neyer mentioned, the Michigan Supreme Court, in a clear case of judicial activism, effectively eliminated the open and obvious doctrine as a threshold issue in premises liability cases. The open and obvious doctrine meant that basically an average person of ordinary intelligence could reasonably be expected to discover and avoid a dangerous condition. The property owner was typically not liable for injury stemming from that condition. And the representative gave some examples, so I will skip those, but they are in my written testimony if you want to see. And so now Michigan is only going to be a handful of states that has completely eliminated open and obvious as a bar to duty and premises liability. And, for decades, this rule served as a clear and objective standard that allowed courts to dismiss meritless claims early in litigation. Without it, judges and juries must now engage in complex factual inquiries about whether an open and obvious hazard nonetheless posed an unreasonable risk of harm. This subjective standard increases litigation costs and clogs judicial resources with cases that previously would have been resolved swiftly. The implication of this new standard set forth by the court will have an impact on all property owners, but significantly on small businesses. Michigan's economy depends heavily on small businesses who employ about half of the state's workforce, and by subjecting them to increased liability for dangers that are plainly visible and avoidable, the current approach imposes unnecessary costs, from higher insurance premiums to the increased risk of litigation. Small businesses are an easy target of frivolous litigation due to their inability to financially bear the cost of drawn-out lawsuits and will be pressured to settle matters even though they may not be at fault to mitigate this cost. And litigation really doesn't just affect small business, it affects all Michiganders. Each year, the Perryman Group does a study of the cost of lawsuit abuse in each state. In 2023, it is estimated that Michigan lost over 97,000 jobs, and residents paid approximately $1,046 per person in a tort tax. This is only expected to increase over the next several years due to the court rulings, as attorneys are expected to collect millions in settlement fees at the cost of our state citizens. The legislature has the opportunity to eliminate the uncertainty and subjectivity of the courts with a standard that will provide clarity and predictability, not just for property owners, but all Michigan residents. NFIB appreciates the sponsor and the committee for addressing this important issue and looks forward to continuing this discussion with both Representative Neyer and the committee, working to ensure that 4582 is fair and clear. So I'm happy to take any questions after my colleagues speak.
Thank you. Good morning, Chair Leitner, committee members. My name is Randy Gross. I am the Senior Director of Legislative Affairs, Associate General Counsel for the Michigan Chamber. We are a statewide organization, as you're aware, representing small and medium and large businesses in all 83 counties. We appreciate the opportunity today to come before you and testify in support of this important issue and help protect our members and Michigan property owners. As you've heard, the state of premise liability law is in dire straits today after the court case in 2023. We would urge swift action on House Bill 4582 to restore the fairness and predictability that had previously been in Michigan for the last 20 years. I won't rehash the 2023 court case. You've heard about this a couple times now. But what is important is it used to be kind of this standard of average person of ordinary intelligence understanding that there was an open and obvious danger there, and it provided some liability protection. The court ruling fundamentally changed the playing field. Now property owners can be sued and held liable for a truly open and obvious liability, something as simple as a rope across a checkout line. The likelihood of the changes is it has resulted in increased litigation. Costs for insurance premiums have went up with our members, and unpredictability. I will work to not repeat everything Amanda said, so she took a lot of my talking points, so I apologize.
Good. Time is of the essence.
Time is of the essence. I appreciate it. So here, there are three major concerns we have right now with the current state of the law, and that's one is it's clearly leading to more lawsuits. Every slip and fall can now move forward, increasing filings and fueling litigation. This is particularly damaging in Michigan because we have a state where we have snow and ice, and those are the majority of slip and fall cases. This has led to higher cost. As I alluded to, we've already been told about members seeing escalating costs and premiums, additional pressures on business cost, and this is impactful to our small and medium businesses especially. And then the uncertainty that goes with this. American Tort Reform Association has already stated that Michigan is a judicial hellhole. This is just now adding more fuel to that piece. We need to reverse this in the state of Michigan, and this is just the start of the problems with tort reform in Michigan. This is not just an abstract legal debate. We know that this is out there. We know that changes are already happening, and we know that the, litigation is already moving forward to this. The ones that benefit the most from this are the trial attorneys and ambulance chasers, quite frankly. So we thank you for the time today. We thank Representative Neyer for introducing this and his leadership. We look forward to working with the committee and the chair and the sponsor to move this forward and address any concerns that may be there. Thank you.
Good morning. Thank you, Chair Leitner and members of the committee. My name is Jacob Manning, and I am the Advocacy and Policy Manager with the Small Business Association of Michigan, also known as SBAM. SBAM is proud to have over 33,000 members across the state in any and every industry you could possibly imagine, and we work to advocate on behalf of Michigan's entrepreneurs. At SBAM, we do quarterly member surveys to try and get a feel for broader trends in the small business ecosystem. Over the last few years, we've been observing some alarming trends, rising costs of healthcare, effects of inflation, workforce shortages, economic uncertainty. These are all keeping small business owners up at night, as I'm sure you've all heard from your constituents. Unless Michigan's premises liability law is addressed, liability insurance will quickly join that list of economic pressures. For more than 20 years, Michigan followed the open and obvious doctrine, meaning that if a hazard was open and obvious to a reasonable person, the property owner does not have a duty to protect visitors from it. This is the predominant doctrine that's followed in the United States, but after 2 Michigan Supreme Court decisions in 2023, this doctrine was scrapped. Under the current legal conditions in Michigan, we're going to continue to see rapid increases in slip and fall cases, which leads to more claims, more payments, and higher premiums. All businesses are going to experience higher premiums due to this rise in claims, adding to the lengthy list of cost increases small businesses are already faced with. And this is really just the reality for an average small business who is not targeted by a lawsuit. For those who are, without the open and obvious doctrine in Michigan law, cases that once could be resolved quickly are now brought to trial, left to juries, and what this means is longer, slower, and more expensive litigation. For small businesses without complex compliance and legal departments, this means diverting time, energy, and resources away from the thing that actually matters to them, which is their business. So who is benefiting from this? Well, you already see the billboards popping up all over the state. I drove by one on 496 this morning. Big out-of-state law firms opening up offices in Michigan because our new legal reality is inviting them here. We've seen how this plays out in other states, explosions of litigation, increases in premiums, and small businesses end up footing the bill. We are urging the committee today to address this issue before it gets out of control. We support House Bill 4582 and urge additional changes to Michigan's premises liability law. Thank you.
Thank you. Now that we heard from those in support that wish to speak, I'm going to go ahead and invite Mitch up. Mitch, if you would just come up here and have a seat. Mitch Albers from the Michigan Association for Justice in opposition of House Bill 4582. It's okay. We're not a firing squad today. It's all good. Thank you.
Good morning, Chair Leitner, Vice Chair BeGole, Vice Chair Carter, and members of the House Judiciary Committee. I am Mitch Albers. I'm legal counsel for the Michigan Association for Justice. Michigan Association for Justice represents over 1,300 attorneys throughout the state, and those attorneys represent thousands of Michigan residents in a variety of legal matters every year. MAJ opposes House Bill 4582 for a number of reasons, but the simplest is that the legislation will reduce the safety for guests and customers at commercial spaces in Michigan. The judicially created open and obvious doctrine has been a disastrous policy for Michiganders for far too long. It has encouraged dangerous physical conditions, creates extra costs for the public, and is especially discriminatory towards the elderly, handicapped, and other vulnerable citizens. As you've heard, the Michigan Supreme Court recently rectified this issue in their 2023 opinion in El Sayed versus F&E Oil and Pinsky versus Kroger of Michigan. In this opinion, the court ruled that the issue of whether something is open and obvious is not evaluated under what duty the possessor owed to the invitee, but instead whether that duty was breached and whether there was any comparative fault on the invitee's part. MAJ's concern is that the proposed legislation perpetuates a doctrine that has grown exponentially beyond the rationales originally expressed in the Restatement of Torts, a treatise describing the area of law and guiding its development, to the point that the landowner possessor has no responsibility for care and maintenance of their property. This does not mesh with either the concept of personal responsibility or good public policy. This is particularly true because current law recognizes the concept of comparative fault in Michigan. In all other areas, and already requires that a recovery be reduced to the extent of the injured person's fault, barring recovery entirely where the injured person's fault is more than 50%. Prior to the Michigan Supreme Court's ruling I outlined earlier, property owners in Michigan had little incentive to maintain and fix anything on their property, especially since the worse condition something was in, the more likely it was deemed to be open and obvious, and the property owner possessor was more likely to escape responsibility and accountability. Oftentimes, counsels and attorneys for property owners have explained to their clients that they do not have to worry about trip and fall lawsuits in Michigan because of previous open and obvious precedent. This cannot be the type of ecosystem that the Michigan legislature wants to create for residents and visitors when they enter commercial spaces. I would also like to highlight one decision from before the 2023 Supreme Court opinion, which demonstrates the ludicrous and unjust situations that HB 4582 could create. In a 2003 case, the open and obvious loophole, like the one proposed here, held that a business could not be held liable for injuries incurred by a blind man who slipped and fell on standing water in a handicapped bathroom because the standing water would have been avoided by the reasonably prudent person. The blind person's inability to see the water was not considered a mitigating factor, and the claim was dismissed because the standing water was deemed to be open and obvious, eliminating any duty of care for the property possessor. The current Michigan Supreme Court opinion still acts as a significant hurdle for injured individuals to bring a successful case against a negligent property owner. A plaintiff will still need to prove that the case involves a dangerous condition on land and the premise owner had notice of the alleged condition. In addition, the plaintiff's status as a trespasser, invitee, or licensee remains important and impacts the duty owed to the plaintiff. And perhaps most significant, as I've already highlighted, is Michigan's modified comparative negligence. A plaintiff that is more than 50% at fault for their own injury is barred from non-economic damages, and this will include an analysis of the condition, whether the condition was open and obvious. I also want to address the issue of property insurance in Michigan and note that property insurance in Michigan and liability insurance is often determined by a number of factors, including climate change and other issues that are occurring. And I will note that the property and casualty lines of insurance last year made $174 billion in profit, as well as made money on their premium underwriting for the first time in 5 years. So if there are issues in the increasing cost of liability insurance, perhaps there are other areas to look at on why the profits for that industry are so high. To summarize briefly before I take any questions, I just want to note that open and obvious endangers the disabled and the elderly. It encourages the creation of dangerous conditions, and open and obvious creates ridiculous legal puzzles that lead to unjust results for injured individuals and allows property owners to escape liability for their negligence. Thank you for allowing me to testify, and I'm happy to answer any questions.
Thank you. We have Rep. Harris.
Thank you, Madam Chair. I guess I have two things, if the chair will allow it. Number one, I think probably everybody represented here today probably is in business to make a profit. So I'm just going to throw that out there. But number two, as I'm going through the bill, on page 3, I believe it's the last line of the bill, it says this act does not apply to a condition that is inside a building or other structure on the premise. Can you maybe explain the inside versus outside and why this is that
Mostly
part's in the bill.
because there's a lot of environmental factors such as bad weather that you cannot predict. And there's a lot of things that a property owner or a business owner can do to control the environment inside their operations. This, to me, was the easy part of the bill to work with. We were open to looking at the interior, but this part here, since the exterior of the building has of the operation has so many different variables, and this seems to be things that, and this is stuff that's a lot of times out of the business owner's control. Okay. So this was the easy thing to do. We're willing to work on the other part to try and bring that open and obvious to the interior of the facility.
I gotcha. Thank you.
Rep. Breen.
Thank you, Madam Chair, and thank you to everybody here. And Rep. Neyer, I hope that you'll be open to working with me and with any other member that would like to see this come to a fair and equitable balance. And first of all, I want to say that I hate the reputation that lawyers get, and I spent a majority of my legal career defending insurance companies and businesses. And for the record, the ambulance chase is an annual event held at Wayne Law, at least when I was there, in which we would, yes, run after an ambulance.
Rep. Breen, we have a couple of other ones, and I know you
It is
want to
a
tell your
bar. It
story,
went
but
to
can you get to
charity.
the question, please?
My question is, given the circumstances that particularly were outlined by the representative for the trial lawyers, that it seems to alleviate any liability on the property owner to maintain their premises. And I'm wondering, where is that middle ground? And are you willing to work to find it? Because right now we have a situation where if we revert to where things were before with the open and obvious doctrine, people like a blind person who cannot physically see a danger that a property owner knew of and did nothing to mitigate the circumstances, how is that fair and just to the people that don't even have the ability to see an issue? And at what point do we make it so that there is a reasonable duty of care for that property owner to mitigate any open and obvious dangers? Would you invite somebody over to your house if there was a gaping hole in the middle of your floor? Shouldn't you maybe put some caution tape around it? Where can we find that middle ground? And that's what I would like to work with you on, to make sure that property owners are protected, but also so are the people that deserve the chance to have their case heard. Because this would even prevent these cases from getting to a jury to determine if somebody's more than 50% at fault for falling through that gaping hole in the middle of the floor.
Oh. Yeah, yes, I'm willing to work on it here, but there's a difference between obvious neglect and then environmental conditions that are out of your control. Spring thaw oftentimes is not only bad on the roads, but it's also bad in parking lots. That's where you get these holes that might just crop up unknowingly. There's a difference between neglect and then obvious things that are beyond the business owner's control. So yeah, I'm willing to look at that possibility. But I think, as we've seen here, her testimony on, the pendulum's swung too far the other way. Now we need to come back to some type of middle ground.
We do, yeah, because the pendulum was all the way over here, then it was all the way over here. We need it to be in the middle. And right now, this takes it too far, in my opinion, if somebody that has, again, practiced both sides of this issue, it's going way too far to one side, and we need it to be in the middle.
Thank you. Rep. Wozniak.
Thank you, Madam Chair. I too will reiterate the concerns of my cohorts here on the committee, Rep. Harris and Rep. Breen. But my question is for both sides. Does this create an absolute defense for the property owner under open and obvious? Because I saw that in my previous career as a litigator, that it did create an unfair situation for visitors to the people, invitees. And so I'd like an answer from both of you, whether or not you would foresee that this, again, creates an absolute defense.
I think it's a great question. We can talk about that a little more. It does put back in place for a defense for external issues. I mean, as the bill stated on that the last line that was pointed out, we're not addressing the internal at this point.
Yeah, and I would argue that environmental concerns outside the building can be predicted by just weather reports or whatever else, wear and tear, and I'd be concerned there.
I don't know. I find the weather reports to be about 30% accurate, so I'm not sure I can predict them, but we do think a defense is necessary, and it moves us back in that direction. And we view this, as some middle ground because it does address the issue that was brought up relative to a blind individual with water in a bathroom. We're not discussing that piece in this legislation. We're talking about external factors that are outside of a building.
So answering my question, you are saying it does not create an absolute defense?
To every situation, no.
Okay. Mr. Albert.
I mean, I agree with him that it doesn't create an absolute defense to every situation in its current form. As you heard Representative Neyer say, though, he's interested in seeing this expanded to inside premises, and the bill is very clear that this is a defense against liability for a owner's duty to an invitee should they be injured coming into their premises at this point, and then if expanded to inside their premises, then inside their premises. And we will see the cases of injured individuals who were wronged and harmed by those defects from being able to seek any type of justice. So yes, it will be a defense. If it's expanded, it'll be inside, and it'll be a defense they get to continue to use to protect and shield themselves from any liability.
Thank you, and thank you, Rep. Neyer. Obviously, we know this is a work in progress. This is the first opening conversation, so thank you for that. With that, I'm going to read in these cards. For 4582, not wishing to speak but supports the bill with amendments. Brian Show from the Detroit Regional Chamber. Supports the bill, does not wish to speak. Drew Beardsley from Michigan Retailers Association. Supports the bill, does not wish to speak. John McNamara from Michigan Restaurant and Lodging Association. Supports the bill with amendments, not wishing to speak. Tom Hickson from Michigan Catholic Conference. Not wishing to speak. Supports with amendments. Craig Puckett, Big I, Michigan. Does not wish to speak. Supports the bill. Josh Lunger, Grand Rapids Chamber. Not wishing to speak. Supports the bill. Eric Chappelle, ABC of Michigan. And we have Beth DeShone from Michigan Forward Network, supports the bill, does not wish to speak. All right, thank you. Next, we are going to move on to Rep. BeGole. For House Bill 4732. My understanding is this is kind of just a quick technical fix to a package that we had earlier on. Wishing to speak on this bill, House Bill 4734. Yeah, I got it. Is Genevieve Marnin from Right to Life of Michigan. If you would like to join the representative, that would be great. Done with that one.
Good morning, Madam Chair and fellow judicial members. I want to thank you for taking up my bill today. The intent of this bill is to allow the surrogate medical decision makers created under Rep. Thompson's House Bill 4418 to consent to medical treatment on behalf of the patient who cannot make decisions for themselves. Genevieve from Right to Life is actually one of my constituents, and she brought this problem to me, and we drafted a fix-it bill, and so I think she would like to testify a little bit more about it.
Thank you, Madam Chair, members of the committee. This was, again, just a pretty straightforward trailer bill for House Bill 4418, the surrogate medical decision maker bill, and it would allow next of kin or surrogate medical decisions made to authorize medical treatments on behalf of incapacitated family members or a close friend, and that's a good thing, and it's in keeping with most states. However, instead of amending Section 466H, the subject of the bill before us, House Bill 4418's enacting section simply repealed the requirement for medical providers to gain consent prior to treating a patient. House Bill 4734, along with the floor sub on 4418, will right this wrong and authorize surrogate medical decision makers to provide consent along with the current recognized patient advocate, guardian, or person standing in loco parentis for patients who are deemed incompetent. It's become standard of care and the hallmark of medical ethics to gain consent prior to treating a patient. This, however, has not always been the case, and there have been egregious stories of forced medical treatment even in recent times. House Bill 4734 is patient protective and will ensure that no patient, whether or not they are able to make their own medical decisions, is ever compelled to receive medical treatment they do not want. And I urge your support and thank Representative BeGole for bringing this forward.
Rep. Wozniak.
Thank you, Madam Chair. Probably for Genevieve. Are there parameters under local parentis as to who can qualify for that position?
You know, I think it's just whatever the standard language is under the bill. We're not changing that language. We're just adding another provision. So right now, the current section of law says that a patient advocate, a guardian, or person standing in loco parentis can make decisions on behalf of an incapacitated patient. This is simply adding that a surrogate medical decision maker is legally authorized to do so as well.
Okay, is there any vetting process?
I'm sorry, for which?
For the local parentis or even the patient advocate or even the nearest relative?
Well, so the vetting process, technically speaking, there's a whole provision in EPIC that if there's a problem with a patient advocate, there's a challenge requirement. They can take them to court. Guardians can be removed if they're not doing the right thing. So yes, there are provisions in place for determining it. In the surrogate medical decision maker, it's a hierarchy of family members. So spouse, adult child, adult parent.
But this bill
sibling.
is outside EPIC.
No, this bill simply says in section 466H, surrogate medical decision makers are allowed to consent to medical treatment.
Thank you very much.
Rep. Breen.
Thank you. Thank you for your work on this. I just want to make sure I understand why this is perceived to be necessary. Is it because there's a fear that there's unauthorized treatment going on? Are people having procedures done without their consent? Because there's like 20 different areas of law to make sure that that doesn't happen.
This was just brought to my attention because it was in the enacting section of 4418, and all this does is it expands those legally authorized people. Right now, under the law, you can have a guardian, a patient advocate. This would authorize legally a surrogate medical decision maker to make decisions on behalf of an incapacitated patient. If we're going to,
I just want to help. I want
Yeah.
to help with this.
Yeah.
This was a technical thing. So if you remember in the Thompson Whitware package,
Yes.
there was a section in there that it basically said it was repealed because there was another section that had referenced basically this part, but people thought it was ambiguous and wanted to bring that back in. So that's the need for this trailer bill.
Okay.
It's to clarify
What about
that section still exists under the new bills.
what about retaining the provision that says nearest relative or make it next of kin to ensure that if absent those other things are in the bill?
Yeah, that's kind of duplicitous, though, because the whole point of the surrogate medical decision maker is to allow the next of kin to make decisions. So it just seemed like it was redundant language because the surrogate medical decision maker already provides for next of kin relatives to make decisions. Does that make sense?
Sure.
Okay. That's it. Thank you.
Okay, well, with that, because this is a trailer bill and we heard testimony on the bills it also affects, we are going to go ahead and bring, Rep. BeGole is going to move House Bill 4734 to report House Bill 4734 with recommendation. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives BeGole.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Pope. Green.
Aye.
Scott.
Pass.
Madam Chair, you have 9 yeas, 0 nays, and 2 pass. The motion prevails.
Thank you, Madam Clerk. All right. With that, we're going to move on to House Bill 4664. Rep. St. Germain, please approach the podium. Okay. Point of order here, real quick. It's my understanding you actually have a H1 sub that you're going to be speaking to. So we can talk about it. We are going to go ahead and adopt the sub so we can talk about it. We're not doing the reporting today. We're just adopting the H1. So I will move the H1 sub for House Bill 4664. Madam Clerk, please take the roll.
Chair Lightner.
Yes.
Representatives BeGole.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shutey.
Yes.
Carter.
No.
Hope. No. Breen.
No.
Scott.
No.
Madam Chair, you have 7 yeas, 4 nays, 0 pass. The substitute is adopted.
Perfect, thank you. Also, with Rep. St. Germain, we have the Macomb County Prosecutor Pete Lucido on Zoom wishing to speak to the bill, and Oakland County Sheriff Mike Bouchard, who also supports the bill and wishes to speak. And then we will also have Kyle Zawacki from ACLU of Michigan, who opposes the bill and wishes to speak as well. Kyle, we'll have you go last. So we will go ahead and have Representative St. Germain go ahead and speak, and then we'll have your prosecutor and sheriff go right after you. Thank you.
Okay, thank you. And thank you, Madam Chair and members of the committee. To set the stage, we have a couple of videos we'd like to illustrate. So we'll play those for you. This was here in Macomb County, or over there. But
She identified as a speed bump.
I'm cruising round. Everybody want know the coat in town. Yeah, the ugly look I beat them bad. Every girl love me cause me not treat them bad. Drop top, I'm cruising round. Everybody want know the coat in town. Yeah, the ugly look I beat them bad. Every girl love me cause me not treat them bad. Cruise me a cruise on the I-95 in a beast mode. Girl by me side give me deep throat, kick it in overdrive. Come from the rest, now a top class life.
sorry about that audio. But as you can see, it's a problem. And so what this legislation does is it ensures public safety. As it stands right now, blocking the flow of traffic is only a civil infraction. It's a fine. This bill, 4664, would change that to make it a misdemeanor, 93 days, up to 93 days in jail, and up to a $5,000 fine. That last video, somebody jumping on your car, it's a problem. And we all have the right to free speech and to assemble, to express our opinions. But where that ends is when you block people or hold them hostage, because that's exactly what's going on in some of these scenarios. People are in their car and being held hostage, or even a form of false imprisonment. That's wrong. I'm going to use I-94 as an example in Macomb County, and actually, we'll say East Side, Michigan. We have had protests. We've even had social gatherings, parties, right in the middle of I-94, 300 people, blocking people from getting to work, coming home, getting to the airport, getting to a hospital. Detroit Receiving is one of our top hospitals. If that were me and people were blocking me and I felt threatened as a mom, and let's just say I have my kids in my car, whether they're grown now, but whether they're 25 or 5, if I feel threatened by a group of people mobbing my car, the last thing I want to do is hurt somebody, which that's what we saw in that last video. We don't want that. Other states have adopted legislation. This bill is not nearly as harsh as some of the other states, but this is a growing concern. I was asked the other day, why did you come up with it? Why did you want to introduce the bill? Well, TikTok, it's some of these videos, and there's way worse videos out there than what we illustrated. Part of the reason, but it's about law and order and keeping everybody safe, not just the drivers, but as you can see, the people in the road, the people that are sitting, blocking traffic. We're all about free speech and assembly, but at a certain point, we need to protect everyone. And with that, I think we have a...
Ready for your prosecutor? Prosecutor Lucido, are you on?
Hi, good morning.
Good morning. Thanks for joining us.
You're welcome. I appreciate Madam Chairman and also Representative St. Germain for bringing the bill. I no doubt believe that people have a right to be passionate about what they do, but they have to do it lawfully. And lawful assembly, peaceful assembly, with or without a permit, is acceptable. When you don't have a law that covers the type of behavior that is happening, you don't protect law enforcement, fire, EMS, and/or the public at large, your constituents. We can only charge what we have in our laws, and not to make excess laws, but we have disorderly conduct or failure to obey a lawful command of a peace officer. When you exceed the limit of the permit, if you get a permit to go and peacefully assemble, that would be on the sidewalk because it's within these permits when you get them where you decide to peacefully make your, I'm sorry, 1 second. Where you make your assembly. But when you exceed the permit, you are starting to put people in danger, and it's just more than a public nuisance. Safety hazards occur all the time. Nobody wants to see these get out of control, but when you block a highway open to the public, what you've done is impeded the rights of EMS, police, fire, and your other constituents that have a freedom of travel. You also jeopardize lives as it relates to having these EMS vehicles, police vehicles, and fire get through because they are there to capture and maintain public safety. So it's a hindering of the motorists that have lawful right of travel on a highway open to the public. Take into consideration balancing both parties' rights. You're restricting the right to travel, but you still enjoy the right for lawful assembly, but illegally. So I applaud a safety net and a standard that would give some teeth to the already nuisances and beyond that are occurring. But when you lane a street, you risk your own life, let alone the lives of others. And in addition, for closing in this, we're only asking that if the police officers are asking you to move and you don't, I don't know what kind of legislator you would be by not maintaining law and order. So thank you for the right to speak today. Thank you for allowing Representative St. Germain to bring this necessary and needed legislation.
Thank you, Prosecutor Lucido. Next, we'll have Sheriff Bouchard. Sheriff, are you on?
I am indeed.
All right, go ahead. You have the floor. Thank you for being here today.
Yep. Thank you, Madam Chair, members of the committee. Thank you for the opportunity to speak and your willingness to address this important issue. I express my appreciation to Representative St. Germain for leading on this matter. Without going into it, we've already heard that it's currently a civil infraction, but a civil infraction doesn't provide meaningful deterrent. We've seen individuals and groups shut down highways with little or no consequences, and it creates a significant risk to public safety. As the prosecutor said, blocking a roadway is not merely an inconvenience, it has life and death ramifications for first responders that rely on open roads to reach people in need. And even a delay of minutes, which I've seen tragically as a former fatal accident investigator, means the difference between life and death and losing someone. And beyond emergency response, blocking roads create dangerous conditions for drivers and pedestrians alike. I mean, in Michigan, we've seen a spike in pedestrian accidents. We've had 7 hit and run pedestrian accidents in Pontiac this year alone, 2 resulting in death and 1 in critical condition. Having people in the roadway is dangerous, plain and simple. And, a person's right to protest does not extend to violating the rights or endangering the safety of yourself and others. So I truly believe this bill also could be strengthened a bit further, because the penalty section currently says an individual who violates this section while participating on an assembly in a highway is guilty. It suggests that you have to be in some kind of assembly. Individuals sometimes do this on their own. We've seen that ourselves multiple times, responding to situations where people are in the road. Sometimes it's a mental health thing, and sometimes it's other things, trying to make a statement. But being in the road is dangerous to the drivers and to the people that are in the road. So I'd encourage you to change that as you consider this as you move forward. But nationally, you've seen also how quickly these situations can escalate into violence, real violence. Sometimes people in cars feel trapped and panicked, and they hit the gas, and you have potentially numerous pedestrians that are injured. You've seen cars being attacked and people in the car being dragged out. So it's a volatile situation. We work to protect protests every day that they happen, to keep them safe and allow them to be heard. Sometimes we have to separate protesters and counter-protesters. So we all believe jealously, and we guard the right to free speech and to have your voice heard. But there's places and venues where that works, and primarily it's out of the roadway. I mean, it's pretty common sense for a lot of reasons. We want you to do that. We want to keep you safe, but we want to keep the traffic moving as well. So I would urge you to adopt this, to make some changes. Again, as the prosecutor said, we're not looking to arrest anybody. We're just, hey, you got to get out of the road for your own safety and everybody else. And if they refuse, and if it keeps building and it shuts down all of those things, it becomes a kind of powder keg. So thank you for the opportunity to speak, Madam Chair. And as I said, law enforcement across the state would appreciate this assistance.
Thank you, Sheriff. And just so you know, the H1 substitute we did adopt today does apply that new language that says it's an assembly of individuals, not just to a group of 10 or more. So we did adopt that change for the substitute. But anyways, with that,
I'm just not sure that assembly is defined. That was my
oh,
only
okay,
concern.
got you.
Putting on my old legislator hat.
Thank you for that. With that, we have Rep. Breen for a question. Oh, wait, I forgot. Hold on. Wait, we're going to do one more. Kyle Zawacki from ACLU of Michigan, wishing to speak and opposes the bill. We'll do you real quick. Go ahead and join the legislator up here, and then we'll do questions. Sorry.
Thank you. Thank you, Chair, Vice Chair, committee members. My name is Kazuaki. I'm the legislative director for the ACLU of Michigan, a nonpartisan nonprofit organization dedicated to advancing the civil rights and civil liberties of all people in the state of Michigan. Our mission is to ensure that the promises within the Constitution and the Bill of Rights are upheld and protected, especially the First Amendment's right of freedom of speech, freedom of assembly, and freedom of petition. We are deeply concerned with House Bill 4664, a bill that would criminalize assembly on public highways, subjecting participants to jail time and fines. This bill is an injustice to our core principles of free speech and the right to protest that are enshrined in both the United States and the Michigan constitutions. Demonstrations on public streets have long been utilized for political speech. Marches, rallies, protests all require a physical space to occupy in order to exist. Michigan's highways do not exist in a vacuum, and vehicular blockades are not a new form of protest. Neither is the government's frequent attempts to suppress these public demonstrations and silence dissent through police force and legal intimidation. We are all aware in this room, drivers hate to be inconvenienced when protests block streets. However, driving is not a right, it is a privilege. Protesting, on the other hand, is a fundamental constitutional right. The Supreme Court has said that sidewalks and streets have immemorially been held in trust for the use of the public to make our voices heard. Currently, there's not a single city, township, village, or county in the state of Michigan that cannot already respond to people intentionally obstructing cars or pedestrians or for trespassing on private property. The unsafe impeding of traffic is already a civil infraction, and current law maintains a balance of First Amendment rights with safe traffic flow and is satisfactory in its current form. If passed, 4664 will stifle protest and speech through fears of prosecution. Many law-abiding citizens would think twice before leaving the House to protest if this bill were passed. That chilling effect is precisely why 4664 is dangerous. These bills may be framed as measures to protect public safety or the so-called right to drive, but they more importantly discourage the constitutionally protected right to protest. With all that in mind, passionate protesters do not take to the streets lightly. They are driven by a deep sense of injustice and want for social change. Studies show that increased criminal penalties do not stop protests completely. In some instances, they can have the opposite effect of increasing the public's desire to participate in protests. When demonstrations across the country are large enough to take over public roadways, the challenge has not been the lack of legal tools for dealing with unlawful behavior. Instead, law enforcement has often used trespass or obstruction laws excessively to charge individuals participating in those protests. Addressing that abuse of power should be the priority for lawmakers in this committee, rather than expanding the list of offenses that police can already use against those near protest activity. And wrapping up, House Bill 4664 would criminalize protests in one of the most traditional and impactful forms it can take, peacefully occupying public spaces to demand change. The American Civil Liberties Union of Michigan urges this committee to oppose House Bill 4664 and maintain the state's commitment to make no law that abridges the freedom of speech or the press or the right of the people to peacefully assemble and to petition the government for redress of their grievances. Happy to take any questions.
Thank you. Rep. Johnson.
Thank you, Madam Chair. Thank you for all the testimonies here. A question for Kyle. And are you aware that there's a man in jail right now for peacefully praying on a public sidewalk in the vicinity of an abortion clinic?
I'm not aware of that specific individual.
He's in jail right now in Oakland County and fined. And how do you feel about that situation?
I would love to know all the details of the court of the issue and on beyond just an individual that has been arrested, to know the specifics of it. And our intake number is open.
That's a very, very carefully crafted answer, and I give you credit for being diplomatic and non-committal. My other statement here is for everybody. What's the difference? I mean, for an average person driving down the road, if they don't know about a protest, how do they know that someone jumping on their car is not carjacking them? I mean, the whole thing is, yeah, go ahead.
No, I apologize for interrupting. I think the law as it's written right now does look at intent and someone who is intent to carjack someone, that would be a separate set of penalties that would be addressed or could be met by law enforcement or to bring that person to stop them from doing something.
Either way, it's going to be very dangerous for everybody involved because
Especially when you're in the heat of the moment and someone's jumping on your car. What if you have somebody carrying, feels like they need to defend themselves. But anyway, moving on, Rep. Breen.
Thank you, Madam Chair, and thank you to the sponsor. I understand the concerns that we have here, and there are really awful circumstances that drive people to take to the streets, and it would also be an awful set of circumstances to have somebody in a vehicle proceed and injure a protester. My big concern here is that we are currently seeing the evisceration of constitutional rights, especially due process in this country. I am extremely concerned about the chilling effect that this would have on free speech and free assembly. And so there are already remedies to ameliorate these situations. The fact that you can already be arrested or detained for blocking traffic or causing injury to somebody else. What evidence is there that changing this from a civil infraction to a misdemeanor, a criminal penalty, would be a deterrent versus the chilling effect that this would have on free speech or assembly? Because as we saw with somebody who was protesting and they were run over by a vehicle, in addition to being seriously injured for expressing their constitutional rights, they're now going to go to jail while they're seriously injured. And so is there actual evidence, because I'm unaware of any, that shows that increasing this penalty would be an actual deterrent?
So as it stands right now, somebody could be charged with disorderly. And as you know, disorderly conduct is such a vague term. It holds no weight. I don't think it's fair for, say, myself, if I injure somebody, that now I have to be persecuted. I'm going to be dragged through court. I'm going to be charged civilly or more. I don't think that's right either. It's not fair.
But this bill doesn't address your liability. It addresses the problem on the protester. So any impact, like for you, and I'm happy to talk through this with you. This does nothing to impact what your liability would be. This is solely on the protesting individual, the person who is expressing their fundamental right to free speech.
There is a time and a place, as you know, that
Absolutely.
we have plenty of protests on our Capitol lawn.
Mm-hmm.
They're wonderful, no matter what side of the aisle you're on. I welcome that. Freedom of speech and assembly is a wonderful thing. It is. But the Constitution does not cover somebody holding another individual hostage in their car. It's not right. And that's what's happening. That is a crime, holding somebody hostage.
That is a crime.
From
There's
traveling.
already a set of laws to address
If you
that.
stop me, if I'm driving down the highway and a group of people are in the road and I can't get through, that is false imprisonment. Where am I supposed to go?
False imprisonment also has a
where am
separate-
I supposed to go?
So
If if a
I guess
group
I'm
of people are
I'm
blocking
concerned.
me and I cannot travel and get to where I need to go, whether it's the hospital or my dad's in hospice, and I'm trying to get to the hospital and you're blocking me from my daily life, maybe I'm trying to get to the airport. I just booked a $5,000 cruise.
And
I'm going
I
to be pretty
totally
pissed off.
understand that. I
It's not
totally
fair
understand
to
that.
the people that want to live their lives.
Mm-hmm. And this is why we're having open conversation. This is good
Very
conversation.
robust
It's all
discussion.
good. But we're going to move on to
Calm
the
down
next
now.
question. Rep. Hope.
Thank you, Madam Chair. The videos that you chose to show were interesting to me and raised a couple of questions in my mind. One was, it looked like if I was accurately seeing what I thought I saw was two causes that are probably considered liberal or left-wing. Climate protesters in one video, and then Palestinian rights protesters in another video. Should this apply to conservatives as well? Because I remember a time not too long ago that we had mostly conservative people, I think, protesting around the Capitol in their vehicles. They were impeding the flow of traffic to Sparrow Hospital during a medical emergency. So that's concerning to me. We can't pick, can't pick liberals and conservatives. We like their cause, we don't like their cause. That's not how the rule of law is supposed to work. And then the other thing about the videos I noticed is that the safety hazard came from the counter protesters in both the videos that you showed. They responded with assault. They assaulted the protesters who were there peacefully. So that's kind of interesting too. I don't know if you have any comment or response to that.
I do, and it does go both ways. And, what happened at the Capitol, blocking traffic, blocking people from getting to the hospital, I don't condone that. That's wrong too. So let's flip the role. Let's just say you come up to a group of protesters and maybe they're pro-Second Amendment and they're open carry and maybe they even have red hats. Are you going to be a little nervous, a little bit scared? Probably so. It goes both ways. And I don't condone either activity on no matter what side of the aisle you're on.
Rep. DeBoyer.
Thank you, Madam Chair. So Kyle, you mentioned something that I'm surprised you actually said. You said that the right to that protesting is a right, and you said driving is not. I can agree with you. The privilege of driving is not a right. But the ability to move freely throughout our state and our country is. And it has been reaffirmed over and over and over again by courts and the Supreme Court. You know that, I know that. We're not talking about lawful protest. We're talking about unlawful protest. And you also know that there is a significant difference. You stated that protests in roadways should be acceptable. Well, the dilemma right there is that on its face, it's unlawful. There's only one reason that you stop traffic unlawfully. It is to disrupt, which by the nature of protest, we agree could be to disrupt. But it's also to intimidate. Are you telling me that by standing in a roadway, your free speech message and position has more clarity and more definition and more results because they've done it standing in a roadway, risking their lives and others? You know as well as I do that it does not. The reality of it is that I'm listening to individuals advocate for behavior that impedes other individuals', rights. You do have rights as a protester. I also have rights to travel freely throughout this country. And when your rights stop my rights, that's where it ends. We know that. We know that court rulings have said that. Your rights cannot supersede my rights. This is an intimidation tactic, and this is a disruption tactic. It serves no purpose to stand in a highway and stop traffic. Representative St. Germaine, I applaud you for coming forward and putting this bill up, because this is the kind of behavior that erodes our society. We can all agree to disagree on things, but when I threaten your safety and I threaten your rights because I believe my position is better, there's the end of the discussion. Thank you, Representative St. Germaine.
I appreciate the listening intently to every word that I was saying there. The specific response that I'd want to say is that, again, it is already a civil infraction to respond to that. The argument that we were putting forward in my testimony was the increase of penalties to a criminal infraction is the line where we are opposed to the bill.
You said you're right to protest in a roadway. That's what you said. That right doesn't
Correct.
exist. Doesn't exist.
I think Hague versus the Committee for Industrial Organization Supreme Court case from 1939 specifically says that it does exist, but that's okay.
And Sanchez versus Roe says that I have the right to travel freely.
Okay, we're gonna move on. Rep. Carter. This is gonna be the last question, because we need to move on.
Thank you, Madam Chair. Real quick, when I look at situations like this, I need to know the reason for. So, if you know statistically, how many times in the last 5, 10 years have people blocked Michigan highways? If you have it, fine. If not, if you can get it to me. I'm just curious because, you know, I'm against writing a law for certain situations and increasing the penalties. Something already exists, and I think that they've been dealt with. Some things have gotten out of hand, but writing a law to legislate certain behaviors, there's a line that has to be drawn.
So
if it's an occasional,
two
if we
things.
expect it to happen more, but how many times has it happened in the past?
While Nathan's looking for something, so specifically to your question, July and May, a couple of instances in Ann Arbor. I don't know if you've ever heard of die-in protests, but it's where people lie in the middle of the road. So that happened in Ann Arbor in July and May. July 26, 2024, and then May 7th, 2025. They literally, it's called a die-in protest. Let's see, Detroit, Michigan, June 28th, 2020. A police SUV drove through a crowd causing injuries. Protesters claimed the officer was the aggressor, while police said they felt threatened and were trying to evade a perceived attack. Flint, 8 hospitalizations, 4 to 5 injuries. The driver claimed not to have seen the protesters. Swartz Creek, 2023. Driver fled the scene. Driver needing hospitalization. Jackson, Michigan, September 29th, 2024. Other people were injured while a vehicle struck the group, not seeing them. But besides that, there is a memorandum from Dana Nessel herself that was sent out to different organizations that basically said she foresees more protests and dangerous situations in 2025.
I'll just add real quick, and thank you, Madam Chair. Glad she's got that magic 8 ball. But when I look at it, when people are sitting on freeways, and I don't like to use Ann Arbor. That's been a different animal since they were running through the streets, weed and everything else before it was legal. What I'm looking at is something specific where people just sit in the freeways and stop that. I'm against that. But, you know, we'll just do a deeper dive. I just wanted to bring that to our attention. Thank you.
Can I add one more thing, if you don't mind? I don't know if you're aware, but there's this new thing where people are planning parties, 200, 300 people, purposely blocking down I-94. It's happened a couple times in the last few months. So we're not just talking about political opinions. We're talking about purposeful disruption to our society.
Okay, thank you, Representative. And thank you for everyone that testified today as well. I have a couple more cards. House Bill 4664 does not wish to speak, opposes the bill. Noah Smith from the Criminal Defense Attorneys in Michigan. Michigan Sheriff's Association, Matt Sexton, supports the bill, does not wish to speak. We already took care of the other business, so with no further business before the board, we are adjourned.